So that's a core principle of this. Some concerns that have come up, that it would, the issue that it is somehow a conflict if the LURB was hearing cases that involved the Act 250 rules that it creates under the statute. As Chair Mahali said last time, it really most, and I did some research on this, certainly at the federal level. If you look at EPA, if you look at the Army Corps of Engineers was a good example. They issue wetland dredge and fill permits. They create the rules for the dredge and fill permits under the wetlands, and the appeals are an internal appeal within the Army Corps, just to a different division of the Army Corps, but it's still part of the Army Corps. So they basically try to say, well, the person who made the initial decision is not going to also hear the appeal, but they're the same organization. They understand their rules. And then that is it could be an evidentiary proceeding and could be de novo. And then that decision from the appellate body could go to court on the record. And I do think courts on the record make a lot of sense. I think that really plays into what courts are supposed to do, but they're not supposed to have a full-blown, in my view, initial evidentiary hearing. I similarly looked at just like Massachusetts and New Hampshire, just like our neighboring states. They also have appeals boards that are attached to in New Hampshire, it's the New Hampshire Department of Environmental, I forget exactly what the acronym is, but their environmental department, and same with Massachusetts, which is similar to the process that I just explained. And I think there is, the district commission in my mind is like the sort of the initial level of the Army Corps, and then that appeal could go to the LURB, which is still part of the same organization as a district commission, but they're at the highest level and they make the decision. So there is no conflict. There's certainly reasons why people want to argue to keep appeals with the court, but I just don't see it as a conflict. And I see it actually as the LURB, as Ron Shem said last time, being able to fully implement its program like FERC does, like the Army Corps does, like EPA does, by making decisions that are before it based on the rules, based on their statutes. And if parties feel that those decisions stray from the bounds of the law or the evidence in the record doesn't support the decision, then you can go to court and appeal, whether it's Superior Court or to the Supreme Court. So I don't think that really, I don't see that as a conflict. So that's kind of the first point in here. So use the LURB as the expert appeals board, as I said, to give more flexibility in managing these cases, and getting good quality decisions and being able to staff the decision based on the complexity of the case and your priorities. So if housing is a priority right now, to the extent that there are appeals of housing, you could direct more resources from that panel to try to move those housing cases along. As we've heard in the legislature over the last number of years, the courts don't like to be told what to make a priority. They don't like, there's some constitutional issues, I guess, around the legislative branch of government telling the executive branch of government how they should operate, but that wouldn't be true with the board. The second bullet on here is about A&R permits, and I basically, it's very, very similar to what David Mears presented, but I really think that for A&R technical permits, I would not send them to the LURB. I think you can have the zoning and Act 250 at the LURB and have that consolidation, but I think for A&R technical permits, Vermont should approach them the way every other state in the country does and EPA does, which is basically having, as David described, decision at the initial level from the division that's issuing the permit, and then an internal appeal through a hearing officer or administrative law judge on behalf of the secretary. The secretary signs a decision. That hearing before the ALJ at A&R could be de novo. You can present evidence. It could be an evidentiary hearing. And again, and I'm happy to provide some of this information as we move into the next phases of this group of like writing a report or recommendations. But New Hampshire and Massachusetts had some good, I thought, models for their internal environmental department in terms of how the hearings are run before the administrative law judge. And I think that's the right system for these technical permits, rather than going notice and comment from A&R, and A&R rarely, if ever, makes significant alterations to permits based on comment, because they've worked so closely with the applicant through the process. And then you basically write in court with the de novo, the court is standing in the shoes of the watershed management division that wrote a stormwater permit, the waste management division that addressed, some contamination at a site, or a discharge permit or air pollution permit. It just seems like we're asking the court to do the wrong things by being the technical permit writer. Again, you could go the permit issuer, the hearing officer process within A&R. You can have a de novo hearing, you can present evidence, you can go back and forth. And then when you get to court, it could be on the record. And courts are, like they do all over the country, like the federal courts do, quite capable of evaluating errors in law in a decision, and whether or not there was not evidence in the record to support a decision, or a decision was really out of bounds. It was arbitrary. It was capricious. Like, those are the high standards of court. They don't have to have another evidentiary hearing on it. You would not be consolidating A&R permits under this model with Act 250 and zoning permits. So I'm sure some will see that as a weakness, but I just think that the zoning and Act 250 go together. The A&R technical permits really are different flavor of permit that, our recommendation is to handle them like they do in other states. And then the last bullet, I just wanted to write this down because I think I made this comment at the first meeting that we had, and it's in, and I got this idea and I kicked it around with people at VNRC because of the debates that we've had the last couple of years in the legislature about who could appeal a zoning permit, really relating to some housing projects, that some of which you discussed in this group, that, people cause frustration, understandably, about appeals of projects that had the support of a community, had gone through a planning process in designated areas, identified in town and regional plans as locations for projects, and then they were hung up in court for sometimes years, and delayed the project and cost a lot of money. And I think there's merit to the idea that if there is a duly adopted planning process, and there's a process to identify an area for growth, and we're specifically in Vermont in the Tier 1 process saying, where is the Tier 1B areas within these growth areas where housing projects are exempt from Act 250? If you're in one of these areas, we could limit the review of a zoning permit for one of these housing projects in the 1B area. So what does that mean? It could mean, as we discussed, that you basically still need to verify that you meet the dimensional requirements in zoning, that you meet the setbacks, you meet the height requirements, you have water and sewer. So the basic sort of building permit elements. There were comments that were made that I thought were good comments about, well, what if it's a historic district? What if there are some other issues? I think as part of this, you could look at, take an historic district. You could have like a series of practices that people would have to meet. It could be like a general permit. So you'd have to, as an applicant, agree to, to develop in a way that met the practices and guidelines for dealing with historic buildings. So that could be an overlay onto the more simple building permit. We could talk about if there are other issues that fit into that category. I really couldn't think of any. But the idea is that if we really want to build housing in these 1B areas, let's really limit what that zoning permit entails. So then there's not much to appeal. There's not really much to appeal if you're really talking about, a building permit. Meet the dimensional requirements of zoning, make sure you have water and sewer, and it'll guard against less opportunities for appeals of projects that have gone through this process. And remember, in these areas, there are already Act 250 exemptions. So it's the zoning permit, it would be the A&R permit. And I would postulate that the A&R permit process that we recommend would be faster, and it would be more predictable. then a full de novo review of A&R permitting in the courts, as I described. And so I just wanted to throw that out there as something I would, like to discuss. I don't know how it fits into this appeals group exactly, but I do think like it would be a better response to the concern about some of these housing projects getting hung up than continually to go into the legislature and having debates about how to limit appeal rights in a way that doesn't violate, people's constitutional rights to due process to protect their property rights, or just is could end up being fundamentally unfair because it could cut people out of the process that have legitimate concern, And on that score, I would note that every other state that I looked at in our region uses the person aggrieved standard for who could appeal, which is basically standing. And that's the standard that we have to appeal that applies to Act 250. It applies to A&R permits. And in zoning, we have this different standards about any 20 people, if you live in the immediate neighborhood, if you're a butter. I'm done. So thank you for listening, and thanks for the time. I appreciate it.
Whose speaker is on that so that we can hear the person live? And I have to.
I don't want that responsibility.
All right, so I'm going to talk right now. Okay. So what we'd like to do is open up the floor to questions for John. So why don't we take people online so that we can listen through the speaker that we have going in the room? And then we can take people in the room because then we're going to have to turn off our speaker. So what I'd like to open the floor up for our comments or questions about John's presentation from VNRC. We can put him on the hot seat, ask him some questions. So I'll start off the conversation because I'd like John to talk a little bit more about the issue of standing, because I have heard from other stakeholders that the failed opportunity or the suggestion in bills that went through the legislature this year, which we're trying to either reduce or increase the number or eliminate the petition standing for zoning cases. And is that what you're talking about, John, when you're referring to the constitutional standard for standing?
Yes. There was a proposal to get rid of, in the zoning context, that any 20 people could appeal. But then the next question is, well, what do you replace it with? And
so what do you replace it
with? I mean, we've argued for years we should have a consistent standard for who could appeal across A&R, Act 250, and zoning permits. And in A&R and Act 250, it's the standing requirement as a person aggrieved with a particularized interest. And it wasn't always that way. Act 250 used to have a variety of different, as Ed could tell us, standards, right? I mean, materially assisting party, substantially affected, or some such standard. And in 2004, we made it uniform with A&R permits through case precedent got to the person aggrieved particularized interest standard. So yeah, that's been our suggestion. Let's have it consistent, and that way we know people's due process rights will be intact if they could show they have a specific injury that could be redressed by the decision. They could get the legal right to participate, but if you don't, then you can't. And I don't know, I think it had a lot of support. I think there's a lot of confusion around what it meant. And there was some desire to kind of cut out standing all together, and that raised some legal issues for me and from other people, and just issues of fairness, as I said. Like you're just like lopping out people who are legitimately affected. They're not, they own property near a project, and their use of their own property could be affected, and you're saying that they can't address those impacts. And so, in addition to the legal questions, it seems, just like I said, fundamentally unfair. So we never really got there, and no change was made this year ultimately. So I assume this issue will come back up next year, and we'll again recommend person aggrieved across the board. But that's why I went through that last bullet in our proposal about, is there a way, and this has been mostly around housing, is there a way, especially in the 1B growth areas, just to limit what the dispute could be in appeals, rather than taking away people's appeals rights, which I think would be better for the housing community, to try to get through the process rather than just trying to just kind of say blanketly, okay, there aren't these appeal rights, and then you're kind of sweeping up people with legitimate issues as well as people who, that's the thing. What's legitimate? What's not legitimate, right? How do you determine that?
No. You also, and anybody who wants to raise your hand, yeah, wait, haven't they in here, and are you gonna be able to be heard?
I don't know. I have no idea when to speak it.
Any folks?
I can talk to them.
Right, yeah, but, or,
Thank you. So Elizabeth Bridgewater with the Wyndham and Windsor Housing Trust. I really like this proposal. I feel like it addresses two things. One is, making the actual permitting process more simple. I like the idea of limiting what's appealable in the process itself for certain areas that we've discussed. I also like the idea of, once an appeal does happen, to speed it up, and there are some ways to do that in this proposal, with the less complex, less precedent setting cases going in one direction and then more complex, and precedent setting going in another direction. So it feels like it addresses, by having a more nuanced approach. It's not like a one size fits all. So it really does enable more complex cases to get a more complex review, or a more thorough review. I guess the question that remains for me about LURB versus courts is the speed issue. Is, can things go faster through the LURB than through the court system? And I understand, I'm not an attorney, so I'm kind of relying on others in the room, but it sounds like through the court system, there's just required time that has to be given for certain steps along the way. And through the LURB, there's a lot more flexibility in defining what those steps are, and therefore defining the speed at which something moves through. And certainly because the LURB has the mandate to increase housing, it strikes me that that's the better place to get more housing, is to be able to have some more power over defining the speed. So that's my feeling about this proposal. I really appreciate you putting it forth. I don't quite understand the whole standing issue as well as you do, and I don't really know what particularized standard means. So I don't know if you'd be willing to give a non-lawyerly explanation.
Yeah, I'll try. I mean, I've tried in the legislature a lot, and it's just basically, it's the concept that exists in the law for any lawsuit you want to bring, is that you can't bring a lawsuit unless you have a specific injury to you that you can't be generally concerned. So, like in the housing context, you can't there's a housing project in, town X, and someone in town Y that's 40 miles away is reading in Vermont Digger about this project and thinks it's terrible for whatever reason, but doesn't live near the project and wouldn't be affected by the project. But yet they, comment on the permit and then try to appeal it you'd have to show that how are you going to be injured by it specifically. It can't be a generalized grievance. Yeah, that's the particularized part of it. And so, I mean, just to be honest, this has been the debate in the legislature. So like in some of the housing projects that we've heard about that have got hung up. Yeah. So if you live in the town, if you live near the project, you'd have to live near the project. You have to show you were injured in some way, like the traffic was going to harm you, like because you drive through that area, or the visual aspects of it would hurt you because you're going to see it. It's going to block your view or something like that. It just can't be like you don't think it's a good idea, or you're just not in favor of that type of a project. So there is a bit of a screen, but it's certainly, people there are certainly people, and I'm sure that in some of the projects that have caused consternation in the housing community, I'm sure that there were people who could probably prove that, they lived, just down the block from the project or whatever, but they'd have to prove it. They'd have to prove it. I know I have certainly seen in my decades as a lawyer, people not get standing because they couldn't show, but it's certainly not like, it's not set up to be the highest of bars. Like if you legitimately live near a project, which is why I go to the third one, was like, because I don't think you can get rid of everybody who could possibly have a legitimate concern. So like, how do we move these things through the process? Yeah, right.
Be a big backlash if we were to go in a direction that would cut off legitimate debate, so I wouldn't have.
Yeah, appreciate that.
I'd like to call on Ron Shems and then we'll get to Ed. Ron, with you.
Thanks.
You speak.
I think, can you guys hear me?
There we go.
Can you hear me?
Wait a minute, Ron.
John, would you mute yourself?
Sorry.
Go ahead.
Yes, go ahead.
Yeah.
Okay. So I think John's proposal is great. I think it's very similar to David Mears's proposal. Just starting with standing, I feel pretty strongly that it's the system that needs to get fixed, and that's more important than and standing or trying to fix the person agrees standard is not a substitute for fixing the system. I think also the person agrees standard is used on the federal level in almost every other state. It's a wheel that's been invented. We know how it works. We're trying to simplify things and not complicate things by creating new standards that haven't been tested yet. So using what we can rely on and what's already been invented, I think is very helpful. The only other comment I have is that de novo is fine. That's a policy judgment for the LURB and for the legislature to pick. There are also other standards. Right now, it's either on the record or it's not, and there's nothing in between, and it's very complicated for a municipality to develop an appropriate record. There are ways to supplement the record, or there could be various ways to supplement the record depending on the quality of it, or if there's been a loss of the tape or a loss of the video. So I'm just throwing that out there as another option that could help limit some of the issues on appeal.
Great. Maybe could you go off mute so that he can get picked up by the camera? Thank you.
Again, this is Ed Stanek, and I did some research. I'm trying to condense this to 2 minutes. Since the last meeting, I looked at Dick Brooks' treatise on Act 250 and planning. I also found this fascinating: Vermont State Government, prepared by the Snelling Institute. State Government, 1965 through 1999. It's a veritable all-star cast of who's who. Wrote essays about all levels of government, people like Jim Douglas, Josh Fitzhugh, Len Wilson, etc. The point is this, again, condensing this in 2 minutes. It was all put together, woven from the same piece of fabric. 24 of the ESA, Chapter 117, was enacted in 1968. Act 250 came along in 1970. And to cut to the chase, an essential part of all this was common sense fact-finding. And it was very important that there would be legitimate and authentic way for the public to participate in all this. These treatises I talked about traced us back to things like town meeting and what have you. They wanted Vermonters to have an opportunity to say something about their destiny. If there is abuse in the process, and there has been abuse over the years, it all began in overdrive when the appeals went to court and the lawyers, and I have friends who were lawyers, by the way, and their lawyers got their fangs into this, and the abuse took place on the court level. Delay, dragging things out, the war of attrition. Yes, there were a lot of people who had party status back in the days of the Environmental Board and to zoning hearings I participated in, but the horror stories aren't true. I defy anybody to go back through legislative history when they did permit reform in 2004, 2005, and point to actual cases of that. The permit reform was driven by disagreement with the substantive outcome of the Environmental Board decisions rather than process. You look at all the cases that went to the Supreme Court during that era of the Environmental Board, and you can fit into a thimble cases that were reversed from the Environmental Board on due process issues. The court, which was not flaming liberals, you had Justice Barney and others running the show at that time. They were strict on due process questions. There was no abuse. So my point is this. The way this is going in Vermont is we're whittling down party status. There will be no legitimate, authentic role for the public to participate. A grieved person, I mean, some of us can get our head around that concept, but you're going to try and explain this to John or Jane public to participate in the proceedings, they won't be able to get to first base. We're going in the wrong direction. So that's squeezing a lot into 2 minutes. I found a lot more, but I'll reserve comments for later on today.
You next talk about David Mears's model. If we can move on, unless Peter on you, so you might want to. So hopefully you can hear me now. Thank you. Is there anyone else who wanted to make a comment on the VNRC model or ask John any questions about it before we move on?
Yeah, this is Warren. Just a quick question, and maybe it's goes for David's proposal as well, but what's left for the environmental court to do? What are these two models?
Well,
Is it just A&R appeals that would come up from, say, ALJ or A&R review?
it could be, I mean, if A&R, you can either send in the A&R permits after the ALJ to the Superior Court, Environmental Division, or you can go right to the Supreme Court, something we could talk about. I talked to some A&R lawyers actually that said that they thought it might make sense to have Superior Court, like do like a pass through and make sure the record is, do like a pass through so that when the Supreme Court gets an issue, it's truly like a legal issue like it is now, like they're not cleaning up record issues. So that can make sense. Enforcement, we still need to talk about enforcement. I think A&R enforcement by the court actually makes sense. That's kind of where the court started, I think, zoning enforcement. I guess could be done a little bit of Act 250 enforcement. So there's an enforcement issue as well. And they would have less work. I think that would free up, that would create a conversation around, I think that the lawyer would need more staff. So do you take, I think that when we had these conversations before, the court system understandably is loath to give up judges, because the court system is bogged down everywhere. So I can see like the judges would be just kind of thrown into the rotation of all the judges, but the staff maybe could be moved. They have some law clerks and they've got some other administrative staff. So I don't know. I think you'd have to look at that, but I don't think the environmental division would need all the resources where it has now. It creates an opportunity too. But yeah, we have to talk about enforcement.
And then conversely, the LURB would probably need some more resources.
Yeah, I think so. I think that's the idea.
I mentioned John earlier, he was on the same CLE for the Public Utility Commission and the Department of Public Service this morning. And they have their attorney pool and their policy folks, which is about 15, all have the capacity to serve as hearing officers. And obviously, this can go from very simple matters to complex, and then not all matters are heard by a hearing officer. More complex ones, and I don't know what that filter is that they use to decide which cases automatically go to in front of the full three-member commission. But there are maybe some in the room knows or online knows what that funnel is to decide which cases are appropriate for hearing officers or not. But I think under the model you're talking about here with zoning appeals, which quite frankly, I never really considered zoning appeals going to the LURB as we were developing this. But this model has that. To me, that's, and I think we heard that's, I don't know what the percentage is. I know it's on our notes of the appeals that go to environmental court or zoning appeals versus adjective.
No, it's a lot of work. Yeah, I mean,
So it's I think it's a significant shift.
yeah. It'd be interesting to know, and I mean, we could research it. I know Brooke has experience with the PhD, but like what those 15, like what's their docket? I know that there's a variety. I know they have rate cases, they have other issues, which are sort of the more complicated issues. Also with the CLE today, there was a theme of, it's not surprisingly how the citing cases have gone up, significantly in number. And it's taking, a much higher percentage of the time of the PUC. And those cases are arguably more complicated than like some of the zoning appeals, even though there's a lot of, we need to be, it would be good to analyze that. And, you know, I don't know if the PUC will enough to understand the nature of their docket.
Let's have Annette, has her hand up.
Yes, regarding the PUC and hearing officers, I think it was pointed out by someone else at a previous meeting. The hearing officers essentially serve in the same role as the district commissions. And so you need to think about it, it's not an apples to apples comparison. It adds time, a lot of time. And there's a whole process that goes on at the hearing officer level. And then there's an evidentiary hearing and briefs, that's after discovery. And then there's briefs and reply briefs. And then you get a proposal for a decision from the hearing officer. Then you get to make comments on the proposal for decision. Then it goes to the full Public Utility Commission and you can ask for oral argument. So the hearing officer concept at the PUC is not really relevant to what we're discussing here, which is appeals. If you want to know more about it, I've lived this world for 15 years. Give me a call. I'll tell you all about what a nightmare it is. And it is a huge detriment to public participation. I will note that on the appeals process that John has laid out, I haven't been able to poke any holes in it. I will say one thing on the standing issue. And that is that one time back with I think the old environmental board, there was a hearing on a rule in Rutland, and Roy Pilcher of the Audubon Society came and he talked about some blue butterflies along a Velco power line. And he said, who's going to speak for the butterflies? And that's always stayed in my mind as and by the way, the PUC uses the particularized standard. They are lenient on it. I do not have any experience with the 10 or 20 people at a zoning hearing. So one of the questions I have is how often is that used with all of the appeals of municipal permits that we're seeing, way more than Act 250 appeals? How many of those involve the use of those 10 or 20 people? Because I have no understanding of how big an issue that is. And I haven't, I know it's probably used, but I don't know who uses it. Thanks.
And I'll just respond briefly to that question because I have asked a number of stakeholders and lawyers, how often have you encountered the petition appeal or standing issue from the municipal arena? And anecdotally, I'm hearing, oh, I've seen it once or twice, very infrequent. However, I think that then the point was made. However, there's at least one case folks can point to where it created very significant time delays. So I think it's one of those issues where there are poster child scenarios where it has caused great delay, though it does not sound anecdotally very frequent. So on that note, if we don't have any more, I'm sorry. Yep.
Yes.
Beg your pardon.
So, yeah.
Yeah,
Okay.
let me turn mine off.
I talk a lot too. so.
Okay.
Yeah, John, just what you're discussing, pardon me? Oh, Peter Tucker with the Realtor Association, is moving like zoning appeals to the Land Use Review Board. Which are, I remember the number of the chart, there was a pretty big number of those. And then they would have to have, as Warren was describing to, some kind of a, you'd have to build a program to manage that, right? What does that look like? I mean, do you think in terms of number of attorneys or, staff that you need to do that?
Yeah, no, I don't know if you have to build a program, but I think you need more staff. I mean, I think that, I think that would have to be discussed about. Okay, you have two judges, right, and two law firms processing all the zoning appeals, all the active appeals, all the AO appeals, doing the enforcement for all of those programs. You're doing that with basically 4 substantive staff people, which I think everyone would agree is too little. Like, if we were going to stay with the court, it's just not enough resources. I think that's part of the problem. So I think if you're starting with, you've got 5 professional board members who are being paid. So then that's 5 people right there getting full-time salaries. You've got 3 attorneys now. So Allison,
3 attorneys, yeah.
yeah. I think you need a couple more attorneys. At least, but I think that we have to talk about it, but I think we should put it in that context, right? Look what we're doing now is essentially like 4 staff people who are only 2 are authorized to hear a case, and then they get assistance from the law firms. But I think, so I think it's a legitimate issue. I think we need to talk about the resources so we don't create a situation that doesn't get better the way we want it to. But I think you'd have the 5 board members and they could each be hearing officers sometimes, or only reserve like the big cases, but they all meet like a few times a year, had a couple more attorneys, and they'd be expert in processing through these appeals. So, but I think it's a totally fair question. It's something that really needs to be analyzed. And the last thing I'll say is I do think that there's been concerns about, like right now the board, the LRB is working super hard. Just got them created, but right away, they're doing this. They're looking at this at 250 tier 3 and going through that stakeholder process. They're providing guidance for the tier 1 mapping, and soon they're going to be looking at all the maps. What's coming is a rule around the forest fragmentation rule, and that's implement that part. But within a year, that should all be done, 1.5 years. So and then I think you're gonna have a lot of capacity at the LRB. Right now, I'm glad it's kind of fortuitous the way, like we're not even, that we didn't give them any appeals authority right away, because the work they're doing now is that's a long list, and it's difficult work. But I think 1.5 years from now, or a year or so from now, you'll have a lot of resources available there. But again, everyone needs to kick the tires on it, and the LRB would need to really do some self analyzing. You're the best to know kind of how your workload is going now, and trying to look into a crystal ball about the future.
Now, one of
You guys hear me? Whoops.
I'll see.
I don't know, this has got to get moved. Okay, I guess.
Can they hear me now?
Do you mind if I try and pick the projector up to mine, just so we can see who's online?
Okay, now, can people hear me now?
Yes,
Keep in mind that we will need to provide the legislature with an estimate of at what cost a transition over to an appellate board. And that's going to require an analysis of workflow and personnel that we have. And right now, our legal staff represents us at the court in appeals that go to the court. So the LURB can be a party to those. So our legal staff is busy litigating cases on appeal, which would no longer be necessary because that function would be eliminated. So there, and then we would have to figure out, everything from personnel to computer capacity of being able to docket all of the documents, that are filed, all of that kind of thing. So there is another step. We're not investigating that yet because it makes more sense to use our resources once we have a model or models to actually analyze in that regard. So we feel like that will be the next phase after we convene with the board and have discussions more about conceptually which models or which components of models that we are interested in pursuing and getting more data input, et cetera, about.
And just Peter, or the Realtor Association. And this, I mean, the appeals, I hadn't really thought about it. We've been so focused on housing, but these would be any appeals factory that they, right? So commercial, industrial, all appeals would be managed the same way, depending on how we end up deciding. Thanks.
Right,
Yeah,
and
everything.
yeah, and what,
Remind you, when you look at the, back to your chart, 10-ish appeal of activities every year, so the same for A&R, and then, and then the zoning is 40, 50.
It's 100.
It's 100.
It's 100 including enforcement and.
Oh, the enforcement, right?
Yeah.
Yeah, at some point we should look at that, the enforcement part of that. But yeah, just the straight up permanent bills.
so I'm gonna try to share my screen. Hopefully this will work. Because I'd like to move now to David Mears's model. And let's see. Let's see. Is that better?
Yeah.
A little bigger than that? Okay.
Brooke, while I mute and unmute my laptop moving forward, so you can just talk sort of at me and I can try and facilitate whoever else is talking.
Okay,
Does that
great.
work?
Yeah, that'd be great.
So are you muted?
I'm not sure. Okay, I think I am now. All right, great. Now, is David with us online? No, Ron is.
Yeah, I don't see him.
No,
That's-
okay.
Yep, David's away.
Okay. So we were talking about the VNRC model, which is a little bit different than this. It seems that this model relies on these ALJ or hearing officer kinds of people. And my understanding is that David was suggesting that that person would act as the trial judge, if you will, that brings the evidence together if it's if it's on a hybrid, you know, he or she would supplement the record, et cetera, but that primarily the decision of that person would become a recommendation, which I think is similar to the PUC model, where you have the one person who then handles all of the logistics and then presents a recommendation to in the PUC model to the full 3-member commission. In this model, it would be to the LURB, I would assume, or to the secretary if it was an A&R appeal. So I have heard feedback on this model that people are concerned that there is an extra step, as Ned had just alluded to, where you have process at that trial level of the ALJ person. But then there is additional opportunity when the commission, for example, at the PUC hears that recommendation, they can give an oral argument. Folks can brief it. So there's a whole nother process that is engaged in. And so I've heard from several people that that's an objection to this because they perceive it as an additional step. Do folks have concerns about that? Do they feel like it is an extra step?
Lon Shems has his hands up.
Ron?
Yeah, John, help me out here, but the way I understood David's model is that it depends on the type of case, where if it's going to be a difficult case, you could kind of dial up the process. If it's a more simple case, it would just be handled by the hearing officer or the ALJ, or if it's a very simple case, even a mediator type role with a party or an ombudsman. So I don't think it was a one size fits all that he was proposing. It was more dialing it up or dialing it down depending on the type of case.
Mm-hmm. Now, Allison Stone and I, our general counsel, and I met with Step Hoffman, who's the PUC general counsel. And because we wanted to understand how they decide and what cases go to the full commission without stopping at the hearing officer level. And I'm not sure that we got exact information about it, but it's the same notion. The bigger cases that they know will go to the entire commission are right out of the gate assigned to the commission. But they have, I think they said 15 hearing officers. Many of them are lawyers, not all of them, but the ones that are not are very schooled in, making these determinations, applying the law. And so it's quite a stable of brain trust kind of folks that have really been trained to do that job and are very effective at it. So the reason why they have 15 hearing officers is the number of cases. It's a very large docket. I think Holly Anderson, the clerk, told me there's like 2,800 cases per year.
Wow.
She said,
That's crazy.
Yeah. She said, in fairness, maybe half of those are cases that are actually, processed other than, an administrative amendment kind of situation where they, might add an antenna to a tower that exists, then it's de minimis, that kind of processing of very insignificant things that are not
Which truth is
contested.
they're like the permitting entity.
Right.
Right. It's
Right.
kind of like adding up all the district commission, even more so though, 2,800.
Right.
A lot.
If Ron is interpreting this right, that the simple cases would be handled by the ALJs, how is this model different than what we just heard? I don't feel like I see the difference really obviously.
John, you want to point that out, or Ron? Tell us how these two models differ.
One of these things is not like the other.
I think there are a lot of similarities.
Okay.
I'm a lawyer, so I'm sure I could find a difference if I tried to, but.
Yeah, Warren.
Mr. Warren,
We'll get to it.
my sense is that the
the LURB, for looking at board models and putting the court aside for the moment, that the LURB probably has the resources or could, with maybe small additions, to do, I think what John was saying before, instead of an ALJ pool, you could have hearing officers, you could have a subgroup, a panel of 3. You could sort of ramp up or ramp down to address the different levels of complexity of cases.
So sort of going to the rocket docket panel
Yeah.
kind of model.
Definitely a possibility.
Okay.
I mean, I think one difference is I try to, I think that this model was built on the notion of a record review, and mine was not. It could work either way, but I was like, as I said at the outset, I wanted to present a model that could work in a de novo review, given the concerns, like the last meeting, we talked a lot about the concerns about record review.
Right, right. Annette?
The problem I have with this ALJ is I think everybody's focusing on efficiency of process and speeding things up. And because we already have the district commission process, I'm not understanding how this is adding an efficiency. I'm seeing that it just is adding an extra step in the process. Now, I think I said at one of the first meetings, I remember I was an expert witness way back in around 2000 or 2001 in an Act 250 case that was heard in the first instance by the chair of the environmental board. And Matt Strasberg reminded me that he was the attorney in the room. So the environmental board did have a process for using hearing officers. I don't know what happened after that. I don't know what the process involved was, but I would be very concerned about this model and adding that extra step where you have to go through a process with the administrative law judge before you get to the land use review board. I'd suggest you find out how the environmental board did it and what additional process there was. But I don't see that this is a benefit. I think the land use review board could have a 3-member panel. It could have a hearing officer, but you need to understand what the next step is there.
Gotcha. Yep.
Megan, I guess this goes, going back to John a little bit. So I'm looking at our charge here. And on the second charge, how to prioritize and expedite the adjudication of appeals related to housing projects, including the use of hearing officers to expedite appeals and the setting of timelines for processing housing appeals. Wondering if you had thoughts on that second charge, and then I'll save my next question for after that, so it's not to be overwhelming.
I'm sorry, just because of all the paper.
Could you mute? Sorry, it's. If you push that. Well, one of the problems.
Now you're both muted. Everyone in the room is muted now.
Sorry, it's whoever's connected to the projector can't mute themselves. That's, I think you're.
I couldn't mute myself. I mean, even now, and I'm not connected. You're picking up though now, right?
I am now unmuted, but do you want to change the settings for Sarah then? Okay.
Do you think that possible?
I'm like,
Could you repeat, Megan?
I'm ready to repeat.
Yeah.
Okay. So, just going back to our legislative charge and the 4 things we're supposed to consider. So the first was stay with the court, go to the LURB, and should we consolidate Act 250 with A&R? And your answer is no on consolidating A&R and Act 250.
Yes.
Yeah. Second question on our charge, how to prioritize and expedite the adjudication of appeals related to housing projects, including the use of hearing officers to expedite appeals and the setting of timelines for processing housing appeals. Wondering if you thought about that part at all, or thinking sort of out loud now, if you have thoughts on how that might work in your, let's go all of it.
So I think the first part is, as I said, I think you could have more more often with hearing officers and 5 board members acting as hearing officers of the panel to basically, if you want to prioritize housing, to basically have hearing officers assigned to move those cases along. You could have guidelines around that. You could, I think legally you could, I'm not a big fan of like the deemed approval of the timeline generally, because it can sometimes force decisions, that aren't like ready to be made and get bad decisions. But I think certainly tight timeline. I think because you're not for tighter, tighter rules around discovery, motion practice, and moving things along. If you want to do for housing appeals, you can do those type of things, and just put more resources towards housing appeals, because you could, and the legislature could direct the LRB to do that. They're not in the judicial branch, so they can actually direct them to do that. But I really do think, I think in 1B, that's like the last part of my proposal, we really move things along by limiting the appeals. I think that's where we really, want housing to go. But even if you're in tier 2 and you have housing projects in tier 2, I think you could tighten up all the process to move housing along. But I think you probably want to do it for almost any project, like you wouldn't want, you don't want undue, unnecessary process. So it would be, certainly you do it for housing, but I think you could probably do it for other projects in tier 2. But you have more flexibility, more options, I think, generally with the 5-member board and some hearing officer staff and more staff generally, more flexibility because you're not in court.
And then on the third one, the role shall include procedures to create a firewall and eliminate any potential for conflicts with the board managing appeals and issuing permits, decisions, and jurisdictional opinions. And that, that's I guess, and you spoke a little bit to that concern of, if you all, part of your work will be overseeing the district commissions and coordinators to ensure that we are getting fair and predictable results every time somebody goes through Act 250. If you're helping with them on the decisions, how do you then do the appeals? And so if there's firewall procedures there.
Yeah, I think that the district commission under the statute is their decision, right? So the board, doesn't make the decision now or when there was an environmental board. I think the assistance to the district commission comes with, Ed and I were talking about this before, the meeting training and procedures. And you could certainly assign attorneys to give advice and help a commission. The environmental board, when I was an A&R attorney representing A&R and other agencies in Act 250 commission hearings, and as the environmental board, this is in the mid-90s, they have an attorney basically dedicated to helping the commissions, and they would rotate it. And then that attorney for that time basically worked with the commission and didn't work with the board. I was talking to someone today, I don't think that was necessary, because I think you could give advice and help a commission make a decision like as an attorney, but that doesn't mean when the decision goes up on appeal that you're like biased. It wasn't your decision necessarily, but in any case, out of an abundance of caution, that's what the environmental board did back in the day. I think the answer, I don't think the reality, and having served as NRB chair, I don't see any world in which the board is kind of like holding the commission hand through this decisions, because they can make the decisions based on the evidence right, and then hold the hearings and then apply the law. I think it's in the training, I think it's in the procedures, I think it's in, procedures around moving things along. So I don't see it as a conflict, we could, if there's concerns, we could talk about like, what would be the vision of, if we didn't have the system, like, what would the board be doing to help the commissions that it couldn't do, if it was hearing appeals? It would be interesting, I think it would be a useful exercise to kick that around. And, we can do that. But I don't, just based on my experience, I haven't seen it, but maybe there's a vision out there for what the board could do if it wasn't hearing appeals. And I'm open to, understanding, talking about.
We have a question on line one. Can you try up your mic and I'll try mine so we can talk?
Sorry, you want me to turn off?
Yes.
Turn the mic or turn the mic.
Don't worry, made too fleeting.
Ron, please go ahead.
Oh, okay. Thanks. I think John's absolutely right. I think this wheel has been invented many times before. Not only did the environmental board have a policy in place to prevent any such conflicts, but you have agencies, at least on the federal level, such as FERC, that they hear appeals, they make permitting decisions, they also do their own enforcement in-house. And so their procedures to keep things straight and to avoid conflicts of interests. They also do the inspections. They work with the licensees. The FEC, SEC, FTC. They're all quasi-judicial boards, similar to FERC and similar to the PUC and similar to the former environmental board. That wheel's been invented before, and if you want, I'm happy to try to pull up some of the policies and share them.
So here's what our 4 tenets for this study are supposed to include. And we just haven't talked as much about some of those things. So we're just bringing those up as we're having this conversation. We should keep in mind what the legislature has asked for, because Lord knows when we go back in January, they're going to be looking for answers on these things.
That's really helpful, and to bring us back to that. And Alfred and I met with Steph Hoffman, also talked with her about, do you have some kind of firewall expressed in a policy somewhere? And she indicated no, that it has not been a problem. But we also had a very robust discussion that actually turned on what John was just discussing about what the role of the lawyer is. So, for example, in our, and again, district commissions and district coordinators are statutorily charged with making the decisions on the JO for the coordinators and on the permitting for the commission. We are not at liberty to monkey with that. We are in charge of the process. So that's what John was suggesting about training and rulemaking and all of those aspects. So it's important to keep in mind that it is not the board that has even now any direct connection to tell anybody what kind of decision to make. And so the focus on this question has been more on the role of our lawyers if we're one program. And so the suggestion was made, wanted to be very cautious. We would err on the side of caution. And if one of the lawyers was asked to help provide legal assistance to a district commissioner or coordinator, and it's usually on an as-needed basis, right? And so that situation perhaps would disqualify that particular lawyer from then if the case went on appeal, to give any legal advice to the actual lawyer or the panel or whomever might be deciding the case. So that certainly is one way to isolate that issue. I don't see it as an issue between the board and a lower tribunal. Okay. I see that more as a concern of who are the lawyers representing, kind of notion. So we're supposed to be breaking right at the moment, but I thought very quickly we could pop up to,
Think one comment about Dave Mears. I had a chance to look it up. Sitting in the room can know, but I made recollection that in 10 PSA chapter 47, in the comparable provision by which the air pollution permits are issued, I remember the language saying it was the secretary that will issue the permit. And I didn't bring that up to question because my memory is correct, and maybe it's not. And that's, the proposal says circular role to the secretary. So the secretary under existing statutory laws is the person issuing, let's say, a discharge permit pursuant to what's in 10 DSA chapter 47. Then if we have it go through the administrative law judge and that same permit under appeal goes back through the administrative law judge to the secretary. You know what I'm saying? It's a circular argument.
yep, I understand what you're saying. Because I think I just delegated that part. I do believe it is reference to be the secretary.
Right, so maybe the statute have to be,
Yeah, it's a good point. We just have to make it's the pro,
it's the commission.
it's the commissioner, right? Yeah.
Right.
Yeah. Yeah, which really kind of out of go. Secretary, you're right, it's the pro forma. Secretary does not review every permit. Maybe this one.
Quick break, just wanted to draw attention, and MSK was not recommending this model, but they were nice enough to, depict it for us. Because they were more interested in recommending an enhanced environmental division jurisdiction to include property issues. But Liam was nice enough to depict if the LUR were to take only Act 250 appeals, JOs and permitting decisions. And we were segmented just for that, those cases. Do we have any questions or comments about the appellate function being only limited to Act 250 jurisdiction? Or?
This board, it's just going back for many years, and maybe this was a lot different under Act 181, but that was what I was envisioning and going forward. And I think I was not as involved in the last go around, but I think we've never had municipal fields go to the environmental board before. So it's one thing of bringing in actually jurisdiction back to the word, basically going back with a professional panel. But I think, so that was the model that I think most people were envisioning. And I do think it's a major shift of taking the zoning appeals, and putting that not only for workload, but I don't know that was what the legislature necessarily envisioned, of having municipal appeals also going over to just mine. So just a comment, but that's what I thought, but really the real alternative was for most people having.
Yeah, John.
Well, on Liam's model, I don't think, if you did this, I think you could certainly send only Act 250 appeals to the LUR, but the LUR could certainly handle that, I think, with aplomb and ease. But I really think it would be a mistake to contain our permits in the court for all the reasons that I had mentioned. So if this was the desired direction to have the LUR only deal with Act 250 appeals, I still think we need to talk about the A&R appeals because it doesn't. I think it's a problem. Like I said, for all the reasons I outlined. Zoning permits around the country go to court, but not de novo. But I can see that. Something I can understand. Keeping zoning in the court, changing the A&R process, and having the LUR or Act 250 appeals. I think Warren's not wrong. I think I think initially, like, and this goes back to, again, and I was talking before the meeting about this recent round of all these discussions started with, commission report on Act 250, the next 50 years, which focused on, reconstituting the environmental board as a professional board and having them, your appeals play this model. I think what's happened since then, and since, and even since Act 181, as we started to think about appeals, and then this legislative session with, more concerns about appeals, it just became apparent that, a lot of the issues within the zoning appeals, that's where the debate about, party status standing came up. So I think the legislature won't be surprised. I mean, we did get discussed a fair amount about, will the appeal study look at housing, including zoning appeals, and, I think the answer was, yeah. I mean, I think we're changing the system. So we're gonna change the system. We can look at the whole system. So that's kind of where, I think it makes sense to like, well, we're here, we have all these smart people around the room representing various interests. So that's kind of bad, the way we have. I think it's been a great discussion, whatever happened. In the end, I think we've done a service by discussing it, and wherever the LURB report lands, I think it would be, the legislature will appreciate having that option or understanding why it's not an option that was preferred, because as we saw, the zoning appeals are kind of gliding into the court.
Yeah, keep in mind that this is part of the statutory charge. We have on the zoning piece on our own.
Yeah.
And it does make sense because what we have witnessed are these serial appeals and, appeals happening on both, and so, I think,
Well, I have to reinforce what John said in 25 words less, and that is that, my recollection is there's never been a comprehensive study of 24 BSA Chapter 117 with respect to the regulatory side of what goes on in municipal levels. We do know, some of us remember back in the mid-80s, there was Act 200 that passed, which scrutinized the planning and enhanced the planning aspect of 24 BSA Chapter 117. So I agree, that was an opportunity to deal with the regulatory aspects of 24 BSA Chapter 117 regarding the appeals.
all right, I think, listen, Thomas, you're in second, this is Thomas Weiss. I would like to have us recall what Representative Mahaley said at our last meeting about having received a report that had just laid out all the options that his committee knew about already and never made any recommendation. So I think the report that the board submits should say, this is our recommendation. We studied these items and we do not recommend these reasons. So that it is clear to receiving committees that there is a recommendation. How it would be. All right, absolutely agree. I was. And I didn't from those reports that he was talking about. But when it came to the committee, they kind of looked at it and said, what's this? It's just telling us everything we already knew, didn't give us a recommendation. Now I follow you. And that's why we're trying to look at these different options, talk about the concepts. And at the end of today, we'll talk about the next phase. For the board to now have this information assimilated and for them to talk about directions and the most promising or the possibilities that they want to pursue. I think are the most promising. I'll get you just. Please.
Thank you, Elizabeth Bergman. I don't know if I have a clear opinion on like where the municipal appeal should go, but I feel like the decision should, if our broader mandate is about like clearing a pathway for more housing to get built in Vermont, then we should be looking at what's the most efficient way for municipal appeals to get heard, because those are the bulk of the appeals that are happening. That's what's standing in the way. So if by moving the Act 250 appeals over the LURB clears up some capacity in the environmental court to hear the municipal, my sense from what I'm learning, and again, I'm not attorney, but my sense is that there's more flexibility in the law. and there was more capacity built over there. Combined with that flexibility, that might do the trick. I don't have a clear opinion yet, but that's my sense. But I do think that should be kept in mind that is the bulk of what's going on. And so whatever the recommendation should be, should address that fairly.
Very important. All right, thank you for being patient.
No, sorry. I was just trying to follow up on that A&R appeal issue.
Yeah.
Just to timely. My recollection is that A&R, maybe it's still sort of varying statute, but they do have an option for reconsideration of decisions. Senator Ann Whiteley would occasionally get tasked with reviewing an internal permit decision. Didn't happen often, and again, I can't remember procedurally where it's varied. I'm just mentioning that because it probably is something that we can look at, allow for an internal and/or review, or have some attorney that's tasked with doing that and it's appropriately screened to revisit the decision, make sure there's a full record from the permitting division department is before it goes to the court. Something we could look at. I just don't remember.
Yeah, I think you're right. I think you're right about that. When I was with A&R last time, we really did a thorough because Gary Chris was a commissioner, and he really wanted to move towards internal sort of hearing office model. We looked at that. You're right, and we looked at tweaking it a little bit to get it more like what we're talking about. But right, the muscles aren't there. They never really get used. It doesn't get used very much at all.
Be creative.
Yeah.
I'm gonna stop it there. Take a 10-minute break. So what time is it? Just for the folks online, we're going to be doing a full reboot here. So we might leave and come back. What time do you want us to come back? 2:52. Okay. Sound good? All right, we'll see what we can do here.